Our next speaker is Robert Bailey, who's the Regional Outreach Officer of the Department of Immigration and Citizenship.
Thank you, Robin, and good morning, ladies and gentlemen. I'd like to thank the Department of Commerce for giving us the opportunity to come and present at these events. They've been rather successful, and certainly, thank you. And certainly, I would encourage everybody to take home the thumb drive, because I'm going to have to give you like Immigration 101. I've only got 10 minutes to get through it, and there are some key messages that I'd like to point out. Thanks, Robin. Okay, the light blue is skilled migration. This is family migration. This is our total program. This dates back to 84, 85, and you can see the percentage of skilled against family programs. Skilled migration is the largest part, obviously, of the programs that the department runs. Just thought I'd put it into context. People that you can employ permanent residents. Now, I don't want to be reading this to you, but these are the reasons why. They're people that have been given permission to live and work in Australia on a permanent basis. They can also articulate into citizenship if they choose. Temporary residents with work rights. These are good ones. Okay, so the partners of 457 visa holders, you can employ them. You're probably aware of well, I'll go into 457s later, but the partners and family members of 457 visa holders can work at anything. They can move from one employer to another. They can, and they're not restricted, okay? You may also find students. I don't know if you're going to find too many international students up here, but they have work rights that allow them to work up to 40 hours a fortnight during semesters, and in semester breaks they can knock themselves out, work as much as they like. There are graduate visas. There's a 485 visa that allows an international student to remain in Australia for a couple of years. They can work full-time during that period. The idea is to allow them to assimilate into the Australian workforce and pick up valuable points ultimately for their general skilled migration application. This is a points-based program, and I'm not really going to go too far into that today. There may be some bridging visa holders that have work rights as well. And so it's incumbent upon you as an employer to check those sorts of things out, and we'll get to that very shortly. Working holiday maker visas, the 417. There's also a thing called a 462. You won't see too many of those, but the working holiday maker visa is not a skilled migration visa. It's a cultural exchange visa. They're for reciprocal arrangements that we have with the country, with a set group of countries, and we have a few more benefits that we give out with ours. So for that 417, if you employ somebody in the region and it's in the either construction, mining or agriculture, which also can include fishing and aquaculture and pearling, then the person could be eligible, if you employ them for more than 3 months, they could be eligible to get a second working holiday maker visa, so stay here for a further year. But you can only employ them for up to 6 months. If you find that that working holiday maker visa holder has the skill set that you require, it may be possible for you to employ them under a 457 or even under the permanent program if they meet the eligibility criteria, and we'll go into those issues later as well. And if they're coming towards the end of their 6 months and you want to retain them, there are possibilities for you to keep them employed beyond the 6 months duration. This is what I wanted to talk about, mostly. It's always been illegal or unlawful to employ illegal workers. Now, there are a lot of people out there and who are not able to work while they're in Australia. They may have visitor visas. There'll be all sorts of visa conditions that prevail that or to not allow them to work or to work under limited circumstances. So there's going to be some legislation that will come into effect on the 1st of June, a couple of days' time. And this is really going to, it'll probably cause a bit of a stir, because as an employer, it's incumbent upon you to know that the person you're employing is actually lawfully able to work. You'll see a media campaign about these issues, and you'll see it on radio and in the press. The government is particularly wary of this, and they're certainly doing something about it. Vivo is a free service that allows you as an employer to check whether a job applicant is actually able to work. And as of the 1st of June, there's a structure of infringements and civil and then criminal penalties that will prevail. So the infringements and the civil penalties are non-fault issues. The criminal, of course, is fault-based. So it's like getting a parking ticket. If the department finds out that you've employed somebody, you could be liable, as a sole trader, you could be liable for $3,060 fine per person who is not lawfully able to work or in breach of their visa conditions. For a corporation, that's $15,300. That's if it gets that far. There is an escalation process, of course. Firstly, we would give warnings, but if an employer chose to ignore those warnings, they're the sorts of infringements that could be handed out. If those infringements are disputed, it could go to a civil penalty, and you could take it to a court. If you're found wanting by the court and don't have our infringement overturned, the penalties then escalate to $15,300 for an individual and $76,500 for a corporation. The criminal fault-based ones work out for, there are two areas there. There are primary offences at $20,400 for individuals and $102,000 for companies. If it's aggravated, it's $51,000 for an individual and $255,000 for the company. Executives also incur liabilities under this, so it gets really quite complex. But the criminal ones pretty much are geared towards criminal activity that is set up where people trading goes on, sexual servitude, those sorts of issues. So the ones that most employers could be liable for would generally be in the infringement notice area and also the civil penalties. And this is based around knowingly or recklessly employing people illegally or in breach of their visa conditions, or referring people for work. So if you're engaged an employment agency and you work with them regularly and you have a contract with them, you're best protected by having that contract altered with a provision that makes the referring agency liable for the check. That way you're covered. In any instance, you're best covered by going to Vivo. Now, on our website, there are actually directions on how to access this. There's no charge for it. You go in, register, you'll get a password that will allow you to check on whether any potential applicant is able to work. You must have their permission. If they don't give you permission, all of a sudden the antenna should go up. You should be wondering why they don't want you to check Vivo to see whether or not they're lawfully able to work. Once you've got your Vivo check, you keep it. You keep that on file because that's your protection in case we go in there and inadvertently you have somebody employed who's not lawfully able to be employed. You can present that to the department, we back off because obviously something has gone awry in the scheme of things. We would also encourage employers, if you've got somebody who's on a visa that allows them to work, that you check from time to time because visa conditions change over a period of time and they may have tripped a wire that then makes them ineligible to work. Okay. 457, we're going to go into these areas very shortly. The 457 visa Everybody's pretty well aware of it, particularly up in Karratha. Labour agreements, we'll go into that. These two down the bottom, 187 and 186, are permanent residence programs. You can sponsor people in under those programs. There are also articulations from the 457 into the 187 and 186. I spoke earlier about people sponsoring themselves in. We're not going to worry too much about that at this point in time, but international students can do that. People who are professionally qualified overseas are allowed to access our programs and put themselves up for sponsorship, either by the family, by themselves, a family that they have here, sorry, by themselves or with state government support. Okay. This is an uncapped program. It means that it doesn't fall within the migration program that I showed you before. And they're certainly not counted in those figures. The people that are on 457s, if they gain permanent residence, then they are counted in the migration program. The visas can last from 1 day to 4 years. It's an option of the employer to determine how long they wish to sponsor somebody in. Now, this figure here, this temporary, migration income threshold salary, it's indexed, goes up every year, so you can expect a change on the 1st of July. And very importantly, with the 457, we made some changes that brought the English requirement up to, if anybody here is familiar with IELTS, the International English Language Testing System, it's required of people under the 457 program to achieve 5 in each of the English testing streams. That was one of the issues. There's a list on our website called the CSOL. So if you're on our website, which is www.me.gov.au, and you put CSOL in the search engine there, it will come up with this list. If the occupation isn't on the list, you can't sponsor them. It's for skilled migration only, not for unskilled or semi-skilled. Yes, sir?
We have an issue with the 457.
Okay. What I would ask is come and see me after, okay? Because I've got to be able to pass this on, but I'll be around after, and I'll certainly be here for the rest of the day. So if you want to talk about particular issues, that'd be good. Okay. Back in the 1st of July last year, we made some pretty significant changes to our permanent sponsored programs. As you can see, the collapsing, we used to have onshore and offshore streaming for various visas for the two programs, the ENS and RSMS programs. And there was also a labour agreement issue. We're down to 2 visas. It's either the RSMS, which is the Regional Sponsored Migration Scheme, or ENS, the Employer Nomination Scheme. It doesn't matter whether somebody's onshore or offshore, they're going to get the same visa. We streamlined the pathway from 457 to permanent residence. If you've employed somebody in an occupation and they've been in that occupation working for you for 2 years, and you're going to sponsor them in for the same job under the permanent program, there's a fast streaming for that processing. Raised the upper age limit. There's no age limit on 457s, however, for permanent residents, used to be 45, now it's 50. English language skills, the RSMS program, up until these changes, only required somebody to have an English level of 4.5 average, which meant that somebody who came in under this program as a permanent resident didn't need to have an English skill as high as those under the 457 program. An anomaly that was fixed at that point in time. The RCB refers to regional certifying network bodies. In Western Australia now, basically it's the one, except for Kalgoorlie. And that is Skill Migration WA. If you're going to use this program, either of these programs, the ENS or RSMS, you've got to get it certified by these bodies who basically put a labour market test over your what it is that you're trying to do. And we'll go into that in a little bit later as well. And this list, the list that I just showed you, has all been consolidated. There used to be separate lists for 457s and the permanent programs that didn't actually articulate. So people were getting stuck on 457s and couldn't move into permanent residence. Okay. This temporary residence transition scheme, I will give you a little bit more detail in that in a second. That's the fast-streamed movement from 457 into permanent. Direct entry stream requires certification from a regional certifying body, and then the agreement stream here is for labour agreements. There are off-list occupations that you're trying to sponsor in. So under that speedy program to get your 457 worker across into permanent residence, you can see under both these schemes, the ENS or the RSMS, the visa applicant, there's no real change there. Under RSMS, we don't go through skills assessment because you as an employer have held that person for the last 2 years and you're satisfied. They also don't have to do the English is also not relevant either there. They've already met the English test, they don't have to meet it for the permanent program. And here, the requirement under ENS also requires an employer to maintain the training requirement that's required under the 457 program, which is a percentage of the salary, 1% of expenditure of your total salary bill has to be spent on the training of Australians or permanent residents in your employ. This is to make sure that you qualify as a sponsor for 457. It also is the same for ENS. It's not the same for RSMS, so there's no training requirement that's passed on under the RSMS program. Under the direct entry, once again, it's all pretty similar, except these things, the assessment under RSMS requires that somebody goes through a skills assessment through TRA. All under 50, competent English, so they've got to meet the English tests and the skills issues. Under RSMS here, you actually have to require the regional certifying body to become involved in that process if you're going to bring them in under the direct program. I mentioned age earlier. There are exemptions for age. If you've got somebody over 50 now and you're wanting to sponsor them in, it eliminates most. They need to have been on this Fair Work Australia high income threshold, which is currently 123,800, and it's indexed. So you can expect that to go up as of the 1st of July. So over the past 4 years, that person must have been earning in excess of that before we would consider them under the permanent program if they're over 50. Or 50 at the time of application. So they could be, at the time of application, they could be 49 and 11 months, we wouldn't care. But if they're 50, that's where the trigger is hit, okay? English, everybody has to do English except those people, citizens of those countries there. They have to do the English test. Now, apart from that, people also have to, for permanent residents, they must meet the character and health requirements. So it's full medical, x-rays, except for children under 11. They also have to meet the character test, which requires them to provide police clearances from every country they've lived in the past 10 years for more than 12 months. So all of this accumulation of data does take a while. I mentioned labour agreements earlier. This is for occupations off list. If you're seeking to employ somebody and their occupation does not appear on this list, then it is possible to negotiate with the department to get somebody in. If you're familiar with the ANSCO codes, any occupation in the 1, 2 and 3 indicative skill levels are fine. If it's beyond that, it starts getting very sticky. We could look at occupations that are at the indicative skill level of 4, but it's a protracted process. It can take up to 6 months, depending on how complex the issue is, because these things are signed off by the Minister. And the whole idea is, because it's the negotiation, the first concession you'd be seeking would be one of the occupation. It's possible you could also seek exemptions or concessions, at least on English. Skill select. If you're an employer and you're looking for somebody, and where do you go? The department has a free service called Skill Select, which allows people who are trying to sponsor themselves in to put in their expression of interest to apply, but they've also got the option to put their CV on our system. So you may be looking for a welder who is wishing to sponsor themselves in. They may also be looking at possibly an employer might want to offer them a job. This allows you to go search the website to see what's on offer. You need an AUS-key, which means that you've got to go to the Australian Business Register, but we've got the links on our website that show you what to do to get there. So they put up their CV. We don't provide any guarantees. All we say is, hey, this person wants to come into Australia. You as an employer can then make contact with them and determine whether or not it's a good fit, and then work out whether or not you wish to sponsor them. Once again, it's free of charge. Bit of information there. This is all on the thumb drive, so once again, I would encourage you to take it. And if you need to speak to me, that is my number. And I do thank you for your attention.